SJC-13800 in the matter of an impounded case.
Turn it whenever you're ready.
Good morning, Madam Chief Justice, and may it please the court. I'm Lisa Lana on behalf of the appellant juvenile. The heart of Massachusetts jail credit jurisprudence is fundamental fairness. Because of this, we award credit in many different contexts where generally it would not be awarded because it would be unfair not to do so. This jurisprudence was developed in the context of adult sentencing. So here, in this case, we must adjust traditional views on jail credit to fit juvenile law and realities. Regardless of the mechanism for awarding that credit, youth matters and must be part of the assessment of fundamental fairness and a proper sense of justice. I plan to spend most of my time this morning on fundamental fairness, which is central to all of my arguments, and then discuss the absurd results that follow if credit is not awarded. The unique features of the juvenile legal system and the uniqueness of the adolescents and emerging adults that it serves compel credit in this instant context. DYS is treatment and carceral.
How do we figure out the custodial part of a DYS sentence when it's not certain the person is going to be in a carceral setting?
Sure. I think that is a question that juvenile court judges are well equipped to handle. There is, in this case, for example, there was on the record and could be done better in the future, I think, as to specific amount of time that a youth spent in DYS facilities.
The judge would have to break that down. So if they have a DYS commitment, they would have to break that, and they were committed for 3 years before the violation.
Yes, of course, Your Honor.
The judge would have to break down in those 3 years how many times was in a carceral setting, how much time was on probation, how much time were they free, et cetera.
And fortunately, the practice of juvenile court is DYS actually can provide a clear layout of that, and that would be easy to put in the record, and it was in the record here, the number of days that my client was spent in different settings, and that's would be the same calculation that any trial court would be making as to how many days someone was spent in a facility. And the juvenile court judges in these counties will know the facilities and know what level of security they are.
The 499 days of pretrial time, what was that credited to?
That was credited in this case only against the adult portion of the sentence.
Okay, so if he's getting credit for the pretrial time, I'm having a hard time understanding how, under the language of the statute, he also gets credit for the post-adjudication time.
First, I think we have to acknowledge, Justice Wojcicki, that there is nothing like this type of YO combination sentence anywhere else in our law, anywhere else in adult sentencing, and because of this, the analysis necessarily has to look different. By the time the adult sentence is imposed under this unique sentencing scheme, and because we view youth differently, this DYS commitment is essentially transformed into something similar to pre-sentencing, pre-trial detention. So it essentially becomes the same as that 499 days.
That's why you argue fundamental fairness, because you don't fit the statutes.
Exactly. It doesn't fit neatly with any of this. And we have to look at the combination of all of these different statutes. Chapter 119, Section 53 has to guide us with everything that we do regarding youth juvenile sentencing.
Fundamentally unfair. Why does it violate fundamental fairness not to give the juvenile credit for the time in DYS, given the combined nature of the sentence?
Because my client spent 18 months in confinement without freedom. He could not walk in and out. That is going towards nowhere. And to him, he even said this.
Go towards the DYS portion of the sentence?
There's no credit for the DYS portion. That is treatment. That's time that he spent without liberty, without credit towards anything. And that is fundamentally
But he's serving the DYS sentence.
serving the DOI's commitment. And significantly, Chapter 119, Section 58 does not refer to the DYS commitment as a sentence. It is separate.
But it's designed to, it provides him this chance to avoid the adult sentence altogether. So if he lives up to his obligations, he doesn't have an adult sentence at all. So it's not, he's serving the juvenile, the youth portion of this in DYS, and he's got an opportunity to avoid the adult sentence altogether. Why is this fundamentally unfair? It seems like it's fundamentally, and just what we're talking about, giving him a chance to avoid the adult sentence altogether, and then he's blowing that opportunity.
So you're correct. The legislature created this combination sentence to be this middle ground, to give, the case law is clear. The goal is to give youth an opportunity to not have to serve this the actual adult sentence, to do treatment. But here, without the credit, this combination sentence is no longer actually a middle ground, and that is what makes it unfair.
How's this different from an adult suspended sentence in the district court? Say,
Well,
suppose someone was sentenced to like 2 years in the House of Correction, a year to be served, the balance suspended for 2 years. Then they violate and they get the year, right? You don't count the year to the second year. It's one sentence. And as at least the appeals court has said, the combo sentence is one sentence.
Of course, Your Honor. It's different in a few ways. One, obviously here that we're talking about a suspended adult prison sentence, and we don't do that for adults anymore. And we do have that available for juveniles in this specific circumstance because we recognize that youth are different. It is also different from a so-called adult split sentence with a house suspended, because we're talking about two different systems, we're talking about treatment and then a sentence. And
Well, you can't have it both ways, because you want the DYS commitment to be treatment, and then you want it to be carceral.
well,
So which one is it?
respectfully, Justice Graziano, it is both. And the case law makes clear that it is both. It is both treatment and it is both penal. And there are many cases that say that. And there is nothing else like this. I actually think that the closest is if adult were to be civilly committed, and there's a few cases I cite in my brief where that is the case, where this court has said that an adult who is civilly committed must receive credit for that time, because otherwise it would be fundamentally unfair, and that does not fall neatly. That also does not fall neatly within the statutes, but it is time spent without liberty.
That's before sentences imposed, correct?
Those cases are before sentences were imposed.
Someone are being held on bail.
And to be frank, I don't think there are any cases, because I don't think there is anything else like this. I think this is a unique circumstances. So the court has never had to consider before this sentence that has these different types of components, where the first component, it really is both of those things. It is treatment. Of course, we all wish that these youth would never have to serve their adult portion of the sentence, but we're talking about the small subset of those youth who do have to, and it is fundamentally unfair for those youth to then begin a lengthy adult portion of a sentence. If my client had received a straight adult sentence of 5 to 7 years, which is what he's now serving, he would complete his sentence by around the age of 21 to 23, which is now. He's in that period. Now, without the requested credit, he will complete his state prison sentence between the ages of 25 and 27.
That was within his, he had the option to avoid that, and he didn't avoid it. Explain to me, you're not grappling with the fact that this is part of his sentence. It's post-sentence, as opposed to being locked up pre-sentence, and you get that time because that would be dead time. You're not making that differentiation.
He's locked up pre-adult sentence. And that, I think, is the portion of the sentence
That's
that
part of
applies.
it was part of the package, right?
And the reason why it's different here, Your Honor, is because we're talking about youth and we're talking about Chapter 11953 and our mandate to view youth differently. And because of that mandate and because of the science, what this court knows very well about youth, youth are entitled to additional protections during sentencing, and that goes to all stages of sentencing. The law cannot be that Chapter 19353 stops. We stopped thinking about adolescent development once the youth has gotten their one chance at a combination sentence. That applies throughout the sentencing process. And
If we were to decide the case, as you urge, I'm concerned that it would create an undesirable incentive to for the judges and the juveniles to give juveniles a kind of the benefit of a split sentence like this at sentencing, because it would diminish the seriousness of the DYS commitment. So could you maybe address that?
if I understand your question correctly, Justice, I don't think that's what happens. I don't think that's a risk that we have to worry about in reality. I think that juvenile court judges are considering the many factors as they must under the statute, and they are crafting sentences obviously very carefully. And the circumstances where a youth is getting a sentence like this are some of the more severe cases that are seen in the juvenile court, but the judge feels, based on a review of all of the factors, that that the youth needs to have the treatment and deserves to be availed that treatment.
Is being given a chance, but the
Yes.
chance comes with a big stick at the end.
Absolutely.
And your proposed solution, in my view, diminishes the weight of that stick.
Respectfully, Your Honor, I suggest that the opposite is actually true. I think that the without giving credit incentivizes youth to opt for a straight prison sentence, to forego treatment that we as a society want them to receive and go just start their time. As especially youth who have adult co-defendants, they're often seeing their adult co-defendants parole or wrap their sentences much sooner than they do because they tried. My client did.
That's why I said I think your proposed solution diminishes the value of the split sentence, both to the judges and to the juveniles.
So I think it is the opposite. I think that if they know that a judge will know approximately how long a youth will go into a secure setting in DYS. Juvenile court judges know this. These are not secrets about with how DYS works. In this case with my client, he still has 3 to 5 years left to serve, even if he gets this credit. He has some. I can't remember the exact amount of time. I apologize, but he still has some amount of time. The juvenile court judges will know this. They are imposing suspended sentences that are long enough that it is not likely that they're actually going to be wiping out their sentences. They still have significant time, so-called hanging over their head. There's still a significant stick, but it is also fair because they're getting recognized that they spent, in my client's case, this 18 months. He spent 18 months that he feels he got no credit for, and he said that to the judge himself.
Well, you say that, but I just don't understand your answer to Justice Wolohojan's, because the practical effect of this is you can kiss these combination sentences goodbye in the juvenile court. I mean, so if we're going to get into a situation where it's, heads I win, tails you lose, where I get the benefit of the therapeutics on the confinement side, but yet you also want the credit for that on the prison side. Why would a judge agree to that? If the judge has already decided that I want to give this is the sentence, back to Chief Justice Butt's point, this is the sentence. You're going to do this DYS commitment, and then there's going to be this other stick. But if you're now saying that outside of the parameters of the statute, out of this fundamental fairness component now, the judge is going to have to consider that whatever the part of the DYS commitment is necessarily now going to be credited on the other side of this sentence. Why would the judge do that?
Well, I think the reality, Your Honor, is that what we're risking is that judges are going to be posing longer suspended portions. And I think they already are doing that. This judge gave my client a suspended state prison sentence that is, there's no way he could have wiped that out with the time that he had in DYS up until age 21. She knew that if he violated his probation, he would be serving some amount of time. And that is simply one additional factor that a court would consider.
They knew they would be serving this time, whatever that time is, not this time minus.
That's the same as, considering any other credit, Your Honor. There's a number of factors that a juvenile court judge is considering under Section 58, and this is just one more thing that they could think about in determining how long of a suspended portion to impose. And again, Your Honors, if I may, if credit is not mandatory, certainly a juvenile court judge at the violation of probation hearing stage must have discretion to award credit. At that point, the juvenile court judge would already know what amount of time had been served had been completed in DYS, and could look at the entirety of the circumstances in determining, what the nature of the violation was, how the youth did, and so that question is absolutely much easier. I still think it's easy enough for a juvenile court judge to do at the beginning of sentencing to factor that the potential credit for DYS commitment portion. Juvenile court judges are thinking about all of these factors. Trial court judges are already, and juvenile court judges are mandated to look at so many different things, and that's one other factor that they would look at, knowing how the DYS systems work, which they do.
Okay.
But again, at this stage of, yes.
I don't think there are any other questions.
I apologize. I missaw that.
No, that's okay.
If there are no further questions, I would ask the court to remand with an order of the additional days and would rest on my brief.
Thank you.
Thank you.
Okay, Attorney Jamalowitz.
Good morning. May it please the court, Emily Jamalowitz for the Commonwealth. A juvenile court judge is not authorized to award sentencing credit based on the post-plea DYS commitment, and accordingly, this court should affirm. I would suggest that the relevant statutes here are clear, both in how they define the combination sentence and in their failure to award credit in the manner that's now requested. As this court knows, Section 58 defines the combination sentence as a commitment to DYS and an adult sentence which shall be suspended. The appeals court has repeatedly construed this language to mean that this combination sentence is one sentence composed of these two distinct parts, these two mandatory components. The juvenile has to do both if they are sentenced to a combination sentence. There's no language in the statute to suggest that these two components should be conflated, I think, in the manner.
Opposing counsel's argument is not that this falls within the statute. I think she concedes it doesn't, but that it's fundamentally unfair or violates the principles of fundamental fairness not to give the DYS committed portion credit. Can you address that?
I certainly can. I think the problem, I think, with the fundamental fairness argument is the fundamental fairness can't trump the legislature's intent. And I think that's kind of why I tried to go through those statutes up front. I think the legislative intent behind the combination sentence is pretty clear, that it is supposed to be a more severe sanction than just a straight DYS commitment. So there's nothing really fundamentally unfair about then imposing the sentence as the legislature has quite explicitly defined it.
Well, I mean, we could find an explicit sentence unfair, but isn't your point that the sentence meets the crime, or the crime's the wrong word, meets it's responsive to the activity and it's an appropriate sentence, not that just because the legislature did it, it's not fundamentally unfair, right?
Right, and I mean, I think in this case, the sentencing judge, who was the VOP judge, made her sort of assessment of the case pretty explicit on the record. I think given the nature of the underlying offense, it was a patently fair sentence under the circumstances.
Combination sentence gives a second chance to avoid the criminal component of it. And so it's not a fundamentally unfair sentence not to credit it, right? I don't know.
Absolutely. I mean, again, my position is certainly the combination sentence in general is a fair concept that, any sort of, the legislature, I think, was clear in defining the combination sentence. There's nothing unfair about imposing it. Any sort of considerations of fairness can't override the legislature's intent there. And then in this case in particular, I think there was nothing fair about failing to credit, particularly where there are these two mandatory components, and the juvenile simply has to do both by statute.
Anything else?
I can address any other points in the briefs. I know there is an equal protection argument, but unless the court has any questions on that.